Welcome to All Things Social Security. Enjoy your video. Good evening. It's evening here. I just wanted to share a video on how I would kind of respond without doing full-blown extra research for someone who emailed me a question. And I'm going to obviously keep it anonymous, but I wanted to help this parent out, at least give my take on this and maybe put her mind at ease. So the question involves an adult child who's in the late 20s, and the child is applying for DAC, Disabled Adult Child Benefits. They do have a lawyer, and the lawyer is stating, I guess, on the application that the disability onset date is on the child's 18th birthday. Now, remember, the child is, say, pushing 30, and in order to get DAC, you have to be found disabled at some point between 18 and 22. If you're not disabled until after 22, can't get DAC. And if you are disabled before 18, but not at 18 or any time between 18 and 2022, you also can't get DAC, right? So it's definitely that time period. And of course, when you do assert that you're disabled in the relevant time period, it has to continue to the present. So it has to be kind of provable all the way to those late 20s we're talking about. So the mom is saying the adult child was disabled well prior to the 18th birthday. And is there a benefit or reason that the lawyer would aim for the disability onset date to be declared prior to the 18th, like the reality is, or is it okay that he's just saying it as of 18? She notes that she doesn't think the lawyer does child disability cases and doesn't know. A lot of us don't do a lot of them, by the way, for various reasons, but occasionally many of us do, but on a limited basis. So bringing the question back full circle, when you're in this kind of situation, when you're applying for DAC, do you say that it happened at 18 if it happened before 18? My take is, and this is off the cuff, I don't think it's really going to matter entirely because they're going to, he never can get, well, he's never going to get paid back, the DAC all the way back anyway, right? It's only going to be till now. And by the way, just for those of you that don't know, the reason why he's probably only applying for DAC now is because one of the parents retired and started collecting Social Security on their work record, or became disabled and started collecting disability on their own work record, or gosh forbid, passed away. So any of those above would potentially trigger his right to file for DAC. Okay. If it were me, and I don't think it's a critical answer either way, so it wouldn't be a fighting point at all. I would probably put onset as early as I think it occurred. However, it won't matter if you handle it a certain way anyway. The reason why I say that is because technically that is when he became disabled. Doesn't mean it's when he's eligible for DAC, and doesn't mean he met that. But if, and because this sometimes happens, and it might still happen, but when I do this for other cases where the person is not, they can't find the person disabled legally or eligible as far back as what I'm claiming. Let's say an SSI case. They're never going to look past the date you apply. So if the person was disabled for 2 years prior or 10 years prior, he can never collect that far. So they don't go and get records. Most of them tell us a year or two before the date he could possibly be found legally disabled and eligible, not necessarily actually disabled. Because I want them to go back, I want the SSA to do as much of the ordering records work as possible. I will say he's been disabled since blah, 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 with the hope that then they order all the way back to them when they plug in their order for their HITMERS, or if they do a regular official medical record ordering. That is my hope, that because we alleged an onset date as far back as we wanted, they do in fact order that far back, even though they can't find him disabled until, well, eligible for DAC until the 18 to 22 range. They've got to find it starting or existing in there, even though it existed potentially before. Had he been an SSI kid because of his disability, it's a little easier sometimes, maybe just a tad. You still have to prove everything else, but they already know he was disabled as a child. But in this case, if the parents had too much money for their child to have SSI welfare, then that's not ever going to be an SSI child, and it's just going to be a DAC child. So I like to put the oldest date I can on any application that is realistic realistic in terms of the date of being disabled. I'm not saying this is the date he's entitled to payments, because first of all, he's not even entitled, again, he's not going to be entitled to payments from the time he was 18 to 22, even if they prove it, because he's not eligible for DAC until, the parent became eligible for his own benefits on his own record or hers. But for the purpose of potentially getting a little bit more consideration of those old records, let's say the application is taken and the SSA switches it and just changes it themselves to 18. I would then also still be getting those childhood records, because if, first of all, the diagnosis might be there. What if they can't find the diagnosis and the way it was diagnosed in the later records, because it was done once and it just carried all the way through without any further re-diagnosing to show the steps for a diagnosis that are medically acceptable for that particular impairment have been met. So that's always something that's in the back of my head too. Let me go back and get when the person was diagnosed and or earlier. But either way, I find prior records of a period that the person cannot collect for and maybe wouldn't even be applicable, like in here in DAC, in a DAC case, they can provide a good perspective of where this medical impairment, mental or medical, has started and progressed. And was it still existing at 18 in sufficient severity under the adult standards? Because remember, the childhood standards are different. And did it continue through 22 or wherever it, arose? But, if you started at 18, they have to find that diagnosis in there and the proof that backed it up. What if they don't find that? What if it's just like a ongoing thing because it's chronic and there's not much you can do about it? So you kind of, I think, want to get those old records, because they're going to show where all that diagnosis came from and on what really substantial basis it came from. It could also involve IEPs from childhood, and those can be really helpful to prove what they can prove. Whether it's set at 18 and you get all those old records anyway for perspective, or you assert it's before 18 officially, I would probably do the latter, but I don't think it's necessarily going to change the case, except you might not get assistance from the SSA to get those older records, whereas you might get assistance. Don't count on it. Never count on anything. Always, as a lawyer, I'm speaking to the lawyers now or the pro ses, never count on, SSA to necessarily get everything you want them to get. I think they try their best, but if you want to be sure it's in there, lift your own bootstrap up and go get it. It's the way I look at it. And that's what we do. We do the best we can with that. But you want that perspective stuff, because it was a childhood disability and not just an 18 childhood. It's, in regular everyday vernacular, a child is actually under 18, right? So I would put the original date, and the SSA is going to adjust it for the technical in such a way that they have to. But if there's a chance that will have the adjudicator ordering all the way back, why not use their help? There might be some less legwork you have to do. And they have their ways. They have their HITMers and things like that. So, and just the regular ordering on, not on your effort, mom, because you probably already work very hard and have been taking care of a disabled child. So anyway, all the help you can get, I think, and it's certainly not welfare help, because this is Social Security, and you or the other parent or both worked and paid for this very benefit. So I say use it as much as you can. And I hope it really works out for you, or for your son, I should say. Anyway, that's what I wanted to share. That's basically my response to how I feel about that question. All right. I'm sure professionals can all disagree. So, and not unreasonably so, but that's my take. All right, guys, have a great night. Bye. Hello again. I hope you enjoyed the video. I hope it was helpful, if not just a little bit informative. In the event you have a Social Security question you want addressed, please feel free to make a comment below and ask the question, even if nothing to do with this particular video. And just a quick, again, reminder, we have our daily video shares and tips around noon every day of the week. And on Wednesdays at 1 p.m. Eastern Standard Time, we have our live Q&A session where you can come in live and enter your questions in the chat. And we all pretty much have a good time for an hour or two. I look forward to seeing you there, hopefully. And lastly, don't forget about our benefactor memberships. They're very reasonably priced. The first one is very nominal, and you get a few perks, but on a bigger scale, it contributes to us being able to fulfill a mission of assisting certain people with representation that would otherwise not be able to get it. We look forward to continuing to do that, and so far it's working out like the bomb. So thank you for being here. I appreciate it. Bye-bye now.